Good evening, Barrister MC. Please, I need your advice. I recently bought a property with 2 buildings on the land. When I took over, I gave all the tenants a 6-month quit notice verbally and told them they wouldn't need to pay rent for those 6 months. Their tenancy agreement with the old landlord states that the tenants are entitled to a 6-month quit notice only. Since I didn't rent the place to them and I'm not their original landlord, I didn't give them a written quit notice because I felt it wasn't necessary. Now, the 6 months are almost up, and none of the tenants has moved out. I'm really worried. Does the 6-month verbal notice I gave them count as proper notice? Or is there something I should have done differently?
Under tenancy laws, a quit notice must generally be in writing to be legally valid. The law requires written notices to protect both the landlord and the tenant, as it provides evidence of the notice and ensures clarity about the terms. Unfortunately, a verbal notice, even with good intentions like offering 6 months of free rent, does not satisfy legal requirements in most cases. Even though she is not the original landlord and didn't rent the property to the tenants, their tenancy rights automatically transferred to her when she purchased the property. This means she is now legally responsible for handling their tenancy according to the law, which includes issuing a proper written quit notice if she wants them to vacate. Since the 6-month period is ending and the tenants have not vacated, relying solely on an oral notice might not provide her with the legal standing needed to enforce the move-out. To rectify this, she should immediately issue a proper written quit notice to all tenants as soon as possible. If the tenants still fail to vacate after the written notice expires, she may need to file for eviction through the appropriate court. Let's all be guided. Always issue written quit notices and follow due process for tenant-related matters to avoid legal complications.